everyone, and thank you for tuning in for another edition of the Florida Appellate Review. I'm Jeff Adelman from Brotman, Nussbaum, Ibrahim, and Adelman, along with Andrew Harris from Harris Appeals. Jen Dinetz is unfortunately not with us today. She got called to trial, so we wish her the best in the post-COVID, well, it's really not post-COVID area of trials, but we're doing trials anyway. So good luck to you, Jen, and we'll see you on the next one. Andrew, I'm going to turn it right over to you because I know on past podcasts we've talked about improper closing arguments, and there was some news just the other day about with some familiar names with more improper closing arguments. You have the floor.
Yes, unfortunately, we both primarily practice plaintiff's personal injury work, so I say unfortunately, but in the sense of another plaintiff's verdict was reversed and taken away due to improper closing arguments. It's another Engle progeny case, R.J. Reynolds and Philip Morris versus Neff from the 4th District. So in 3 consecutive weeks, the 4th District has issued opinions in Engle progeny cases regarding improper closing arguments from the same plaintiff's trial firm. And in this instance, in this 3rd case, the 4th District, just as it had as the prior week in the decision Neff Foods. So in this decision in Neff, the 4th District held that the improper closing argument was harmful to the tobacco defendants and required a new trial. Now, there were some similarities in this case in terms of the impropriety of the closing arguments to the prior 2 cases mentioned, but there were also, the 4th District actually held there were 6 different areas of improper closing argument in the Neff decision, and the 6 different areas where the trial court erred in overruling tobacco's objections, quoting from George Orwell's 1984, which the same passage had been quoted in prior decisions. In this case, there was a quote from Dr. Martin Luther King, and it's a quote we love about the moral arc, bending towards justice, but the 4th District held that it was improper. The 4th District also held another reference analogizing the tobacco industry as the enterprise of death. The other areas included misstating the evidence, attacking the defendants for conceding medical causation in the case, and the last area of impropriety as to the overruled objections was where plaintiff's counsel, the appellate court held, had injected his personal opinions. As the court noted, none of these comments prompted a, quote, logical analysis of the evidence, but rather were designed to inflame the emotions of the jury. Now, so in this case, there were not references to the Holocaust or the Nazis, which the 4th District in prior opinions in the prior weeks had held were improper and had been egregious in those cases. And so in that sense, there was not a repeat there, but as I said, there was a series of improper closing arguments here in these 6 different areas that the 4th District in this week's opinion held warranted reversible, were reversible error. Now, like the prior case, Neff Foods, here, why were the closing argument improprieties deemed harmful and not harmless? Although the court again explained that what plaintiff's counsel requests and what the jury awards is not dispositive. In this case, this week, the jury awarded $4 million in compensatory damages and $6 million in punitive damages, phase 2. And so essentially the arguments worked with the jury or had an effect. Now, does that mean if the jury had awarded less than what the plaintiff requested that there wouldn't be a new trial? No, the court made clear that it was not determinative, but it was a factor. And the other strong factor as to why it was reversible here is that the comments were not brief and isolated. The court held, the majority recognized or held that the errors permeated or pervaded throughout closing argument through both phase 1 and phase 2 with punitive damages. And so I don't think the opinion should be taken as a sign that you cannot use rhetorical flourish in opinions, that you can't use vivid imagery. Both Judge May in her concurrence and Judge Forrest in his concurrence, I think they both made that clear that as did the majority here, as did the prior week's courts, it's not that you can't use creativity. It's not that you can't use vivid imagery. It's that there are certain areas which are off limits. I think the court has sent a strong signal to that. George Orwell, Big Brother, the Nazis. I know the concurrence, Jeff, you're going to talk about Judge Forrest and his discussion of different topics. You can go take it away right there. Go.
It's very rarely do you get to see something this good in a concurring opinion, but Judge Forrest gave us a little bit of a treat here. In Kaplan, we concluded the plaintiff's counsel took a calculated risk that he could make a circuitous comparison to tobacco, acting like Nazis, and get away with it. But Judge Forrest takes it a little bit very further. One would think that an appellate court would not have to inform counsel or trial court judges of the inappropriateness of comparing the opposing party directly or circuitously to historical or fictional villains, such as the Nazis and Big Brother. Likewise, comparisons to the Taliban, ISIS, Al-Qaeda, Stalin, Pol Pot, Bull Connor, the Unabomber, Cruella de Vil, Hannibal Lecter, the Wicked Witch, Simon Legree, vampires and zombies are also off limits, but that's not an exhaustive list. So now we're going to add to that. No, we're not going to add to the list, but you get the picture. It's, you know, sort of like the smell test. You know it when you hear it. But I mean, these things really shouldn't have to be said. It's not appropriate. And the judges have made it very clear that you're risking giving away your entire case, doing it all over again by bringing up these type of visceral individuals, fictional or historical. Definitely.
And although this was the third straight week with an Engle progeny case with a reversal, I think there are some parts of, or in fact, I know there are some parts of the opinion which have a broad spectrum of applicability. I'll just bring up two of the areas which I know frequently come up with in civil cases. During closing argument, plaintiff's counsel repeatedly argued that the tobacco companies conceded the decedent, the Engle progeny plaintiff who had died, was addicted to cigarettes. Reynolds objected to the arguments as a total misstatement, which the trial court overruled. Plaintiff's counsel characterized tobacco's defense that the decedent's addiction did not cause her disease as the last refuge of the scoundrel. And this was objected to as a personal attack on counsel. So we see that. There was also, during closing, another area, we often see times, right, where defendants may admit liability just before trial. And plaintiffs sometimes want to utilize that admission in their cases. Well, here, the 4th District made clear that was improper, and it's not limited to an Engle progeny case. During closing, plaintiff's counsel chastised the tobacco defendants for admitting medical causation during trial. And here's the quote: after the judge read to you, they deny everything. In late March 17th, the morning after Dr. Burns, who was a plaintiff's expert, was on the stand, they admitted that her smoking caused cancer after denying it. The trial court overruled the defendant's objection to an attack on the defense. So anyways, it's another example. We see that come up. You've got to be really careful. This is not just limited to Engle progeny cases. In trying to utilize a late admission. Now, there are times when the door may be open. If a defendant gets on the stand and tells the jury, look, I've taken full responsibility. I've admitted liability here. I'm doing the right thing. Could that open the door to the timing? Maybe, but unless the door has been opened, stay away. My strong advice would be to stay away from trying to utilize the timing of the admission of liability. So those are just a couple of the areas from the opinion that are not limited to Engle. Both, my takeaway from the opinion, I know, Jeff, we both have a similar, I think, takeaway from this is, as we've said before, sometimes what we think sounds good in closing argument to ourselves, looking at a mirror, may not come out so well when it's before a jury. And have somebody from your office, have an outside friend, whether you type it out or speak it, let somebody independently listen to it, because it may not come across. I think we all know now, right, to stay away from the Holocaust, 1984. But I kind of knew before reading the opinion, but now it's in print. Right, exactly. And And I think, yeah, and the fourth district made that clear, is we don't need to write these things out. There is a compass where the line is too far, and you can't just sit back and wait for an opinion from us to tell you not to do it. So you're right about that, Jeff.
But if you were waiting for it, here it is.
Here it is, right. I think it's rather fortunate here, frankly, that the appellate court did not refer the attorney to the Florida bar. In a case last week, I know, Jeff, you were away on vacation. The fifth district in a case referred an attorney to the Florida bar for deposition misconduct. And there have been, multiple courts which have, the appellate courts have sent the signal to trial judges, to intervene, be vigilant, impose sanctions, whether it's attorney's fees, striking pleadings, whatever. I think we should all be expecting that, could happen. And as we've said before, regardless of the deterrent of sanctions, from courts or the bar, whatever, there's a moral compass of professionalism for all of us to practice, I think. It doesn't help any of our clients in our particular cases, our other clients on both sides, whether it's plaintiff's counsel, defense counsel. This is a nonpartisan, apolitical issue. I think the message from the appellate court here. But as I said, also both Judge May and Judge Force, they recognize, imagery is okay. Vivid imagery, we're not trying, they're not stifling all closing arguments, you're entitled to be passionate about your clients on both sides. You're entitled when, frankly, one of the comments in here, the enterprise of death, which the fourth district held was improper. If someone had asked me whether the enterprise of death was a fair comment for the tobacco defendants, given the evidence of their conspiracy, I would have probably said that fits, that's consistent, that's supported by the evidence. And
I think that there's something to be said, though, about them looking at the prior cases involving the players involved, that they're not going to get a break when their history is using Holocaust imagery and all that. So
right.
there's just not going to be that, this is a one-off.
Right. And I think you make a great point. I think if the enterprise of death comment had been there in isolation, I think we probably would have had a much different story. But because there was such a degree of what the appellate court held was improper closing arguments, and the heightened, the 1984 passage obviously was one here, the Martin Luther King reference here, but just the overall totality of the circumstances that the appellate court held warranted a new trial. And so it's going to be a redo, unfortunately, for the plaintiff here to start from scratch. $10 million judgment reversed for a new trial.
Don't like to see
so I think we're going to transition, I think, to your case. You've got a fascinating case on partnership or legal fees when an attorney leaves a firm.
It's a very interesting case from the second DCA, the Shearer case. It involves the breakup of a law firm where one attorney brings the case into the office, the Shearer case, which was unfortunately multiple parties, including a wrongful death. There's a personal representative involved there, but the facts of the case are really irrelevant to what we're talking about here. We're talking about the attorney's fees. And the attorney Patsko brought the case in, and at the time the firm was Austin, Rowe, and Patsko, and then he decided to leave. And when he left, he notified the clients that he was leaving, and they chose to leave the firm and go with him. And after litigating the case, they were able to arrive at a settlement, and then the fun began. What should the former firm receive in attorney's fees? What's appropriate here? And originally, the judge had said that, well, it's based on a percentage of what the former partner's equity was in the case. And the second DCA said that is not the standard. They said that you should be looking at the 1982 Florida Supreme Court case, Rosenberg versus Levin. And that basically the former partner's work while he was working for this under the flag of the old firm, that counts. Because again, there was no offer on the case or anything like that when Mr. Patsko left. But the work that he did at that time, sure, you're entitled to quantum merit for that work. But it doesn't stop there with the opinion. The court wanted to make it very clear that a contract between the clients and the attorney is much different than just in regular business. They didn't want it so that a client, if they were unhappy with their lawyer, and just unhappy with the lawyer doesn't have to do anything wrong per se, but to be captive to staying with that lawyer or face a breach of contract. So they made it clear that the quantum merit is the correct way to calculate the entitlement of the former firm or lawyer involved. And this court in Shearer really went back to this Rosenberg versus Levin case, that this is the correct way to do it. Again, looking at a contingency is a contingency fee case. The court also made it clear that it's not the only way you calculate it. You do have to look at the whole picture, the totality of the circumstances. Like if, for example, all the work was done at the old firm, and then all of a sudden, after an hour's worth of work, the case settles, there's has to be some acknowledgement of that. Also, in the case of the Supreme Court case, Rosenberg, in that case, the attorney's office agreed to a $10,000 cap for a certain amount of money on the case. So it wouldn't be fair for them, even though they had done work exceeding that, to get more than $10,000 when the case, I think the rule on that one, it was $500,000 settlement, and they were only going to get more than $10,000 if they got over $600,000. So I think that that's an important distinction there, that, you're not going to get a windfall if you were only going to get 10,000. You're not going to suddenly wind up with 50,000 because your work rose to that level. I'm trying to think if there's anything else. It also talked about when lawyers leave a law firm and what the correct way to do it. And the judges were very specific that in the old days, well, the lawyer would leave, he'd take the file with him, and that's it. What's required is for the leaving lawyer, for lack of a better word, to try to deal with the managing partner of the firm and say, look, we need to send out a letter, that I'm leaving, and if you want to go with me, you can do that. If you want to stay with the firm, that's fine, but we have to do it. Now, if you can't get cooperation, you can unilaterally send the letter. But if there is cooperation, you have to work with your former firm to put something out there. So I thought that was particularly interesting, and it is something that does come up. I wanted to also direct your attention, Andrew, you had brought up a really good point about footnote 9 of the opinion. I was wondering if you might want to pontificate about that a little bit.
Sure. So the court here was not addressing in the opinion what the court emphasized in footnote 9 is we are not here addressing the rights that the partners may have to each other or the shareholders to each other if they have their own contractual relationship specifying the money that could be apportioned out. In other words, in plain language, the partners could have had their own arrangement with each other to specify what would happen when one partner, whether a minority partner or majority partner, leaves a firm with a contingency fee case. And in this case, as best as I could read the opinion, there was no such contractual establishment. And so the second district resorted to the common law or determining, trying to reconcile the past case law and announce the rule that it did that you articulated. And so I think the message to take from it for everybody out there, now it's easier said than done, as we know, I can personally say that, having left my old firm, is that the best thing to do is to have everything laid out contractually when you form a partnership, a corporation, a PA, with your fellow partners, with your fellow shareholders, because it's the same advice we give to our friends, we give to our clients. Like I said, it's easier said than done. I know sometimes there are young lawyers out there and they're offered an opportunity to be a partner or a shareholder at a firm, and they're presented with a take it or leave it document, and there may not be negotiation. And so that, there may not be the ability, but if you're in position to negotiate, I would highly recommend folks hire business litigation experts, and have everything laid out contractually, because it sure will make things a lot cleaner, a lot less expensive, a lot more beneficial, personally, financially, emotionally, if a firm does break up, if there is a business divorce, and not for nefarious reasons. As you mentioned, Jeff, there was no indication here the breakup was, it was an attorney leaving to go to another firm. That happens all the time. But I think that folks who, form these business contracts at the outset could avoid a lot of heartache, a lot of litigation, as I said. Now, there is the question, which is unresolved there. There could be a contractual arrangement that partners have, which is against public policy, or which is unenforceable, because as you mentioned, Jeff, ultimately, the client has to have the free will, the ability to be represented by who they want to be represented by. So that's just more reason, I think, for you to, retain experienced business litigation counsel if you're in position to do so when you form a partnership. On the plaintiff or defense side, although this was a contingency fee case, I think on the defense side as well, that would be, I know, my advice to take from this.
Absolutely.
For everybody.
I think that's, again, that is, good advice. And I think that, it's encouraged. It's not always done, but obviously it makes things a lot easier. I wanted to point something else out about the opinion that I thought was rather interesting. I just had it up. But in this particular case, there was also some discussion about a prior case involving the Searcy Denny law firm, Searcy Denny Southern 2nd 366. It's another Florida Supreme Court case where a client left with an associate who had left Searcy Denny. And the court really is going to rely also on Florida Bar rule regulating the Florida Bar 4-1.5 subsection B. And I'm just going to read directly from that. However, because the factors relevant to the determination of the reasonable value of services rendered will vary from case to case, the court is not limited to consideration of the Florida Patients Compensation Fund versus Roe. The court must consider any other factors surrounding the professional relationship that would assist the court in fashioning an award that is fair to both the attorney and the client. For example, the fee agreement itself, the reason the attorney was discharged, the actions taken by the attorney or client before or after discharge, and the benefit actually conferred on the client may be relevant to the determination. So it's not just the amount of hours that you put in. Everything's got to be considered. But in this particular situation, they looked at the hours that the former partner was there, and that's how they determined what the former firm was entitled to. But yeah, it was a really interesting case, and I thought it's relevant probably for a lot of our viewers, listeners who either have left or are thinking about it and what kind of considerations you need to think about. But,
right, and this may not be the end of the road for that case. It's possible that that Supreme Court review is requested. As you mentioned, the leading cases here that, the Rosenberg and the Searcy Denny case are state Supreme Court cases. And there's not a lot of law out there over the course of Florida jurisprudence on partnership breakups, corporation, whether it's a corporation, a PA, shareholder disputes, and so it may be something for the Florida Supreme Court to, although I thought it was a really well-reasoned opinion.
I thought it was too, but like everything else with law, it's fluid. So.
Right, exactly.
Let's go back. Let's turn the corner and go to your grand finale, Andrew.
Okay, so the last case, and it's one of these It's a Section 57105 case, but it fits into the e-service rules. And it ties into one of my specialties that I like talking about, proposals for settlement. And the case, it's Gearty versus a whole bunch of appellees, but Gearty versus Stewart, Gearity was the appellant versus Stewart, 5th District decision. Now, the decision itself, it's a very brief decision. The moving party, the defendant had moved for 57105 fees at the trial court level, and the fees were denied. And the reasoning of the trial court, which followed the then existing precedent of the 5th District, was that the Section 57105 movement had not served the safe harbor motion. It did not look, walk, and talk like a court filed document. Now, this was a few years ago when the document was served. And so under the then existing precedent of the 5th District, that Section 57105 notice was deemed defective in our case here. Now, fast forward, the Supreme Court in Wheaton versus Wheaton in 2019, they held that under the then existing rules, Rule 2.516, proposals for settlement and Section 57105 safe harbor motions, because they are not court filed documents, they didn't need to look and walk and talk like court filed documents. In other words, they didn't need the subject line. We all get these court filed documents. We're all served them, right? We know how they have the name of the party serving and the name.
Sure.
And so the Supreme Court held in 2019 that under the then existing Rule 2.516, that the proposals for settlement and then and by analogy 57105 safe harbor motions didn't need to comply. Okay, well, fast forward to today and the 5th District opinion, they held that the 57105 in that case was properly served because it did not need to comply with the e-service rules. It did not need to look, walk, and talk like a court filed document. So the 5th District reversed the trial court here and said, based on the Wheaton case, we reverse and remand for the trial court to determine whether the 57105 motion should be granted on the merits. In other words, it was procedurally proper. But, and this is the really important thing for all of us here, both the majority opinion and the concurring opinion here noted that earlier this year in April 2021, the Florida Supreme Court amended Rule 2.516. And as best as I can interpret the rule, and I think the concurring opinion without taking a position said, it appears now that these Section 57105 safe harbor motions, which is the 21-day notice, and by analogy, proposals for settlement, they cannot be filed when they're served. But under the amended rule, which was amended as of April 2021, these documents need to look, walk, and talk like court filed documents. And so what does that mean for everybody out there? If you serve a proposal for settlement and your subject line says proposal for settlement served by plaintiff John Smith or PFS by State Farm, and you have a little email, hey, opposing counsel, please see attached the document. That doesn't look, walk, and talk like a court filed document.
No.
Look. And so it's going to be really hard for someone to go and enforce that proposal for settlement if it's rejected, or that 57105 safe harbor motion if you go to enforce it later on. And so the message which I've given before, and I'll say it again here for everybody, for all the people in your offices, your paralegals, your legal assistants, your attorneys, if that message hasn't been sent, send it out to everybody to have those proposals for settlement and those 57105 safe harbor motions look, walk, and talk like court filed documents.
Andrew, let me ask you a question about that. I mean, I think I understand why, but why is that so important to the court to give it that type of treatment when you're sending that type of a motion?
So my reasoning, as best as I can tell, and when the court amended the rule, the Supreme Court, they didn't get into the public policy necessarily, nor did they need to. But under the common law, of course, in Florida, parties bear their own attorney's fees and costs. Well, there are exceptions, contracts, but here we have two statutory exceptions. One is proposals for settlement, of course, by rule and by statute, and Section 57105 in particular. These are sanctions, right? And so by having these documents look, walk, and talk like court filed documents, you as the recipient know that it's meaningful, right? I mean, what's the purpose of a PFS? The goal is to settle cases, right? And it's not to set people up and to trap people. And obviously 57105, I mean, the goal is not to hit somebody with attorney's fees and costs, right? The goal is if somebody has filed something not in good faith, and the recipient to take a second look and go, you know what? I'm going to now reevaluate my position, and I'm going to withdraw the pleading, right? And so I think because of the imposition of sanctions, what it means is, just like when a court filed document comes in and we all as attorneys, our staff, we need to respond, right? A request for discovery, a motion for summary judgment. And so to bring the formality here to proposals for settlement and 57105 safe harbor motions, just like because of the significance of these documents. And that's what I think is.
Yeah, it's kind of, I think it's obvious. And I think that the seriousness when you read a 57105 or a proposal for settlement, or the thing that scares me, request for admissions, when I see those come in, I always kind of like, my ears perk up a little bit more for those documents than others. But again, when you see that it's a formal subject line like that, it's drawing your attention. Nobody said, well, I didn't realize that it was a sanction motion or anything like that. You can't have that. And there's no doubt about it if you put that in the subject line.
Right. And it also, of course, goes to the importance for everybody who's in position to have a secondary email address. Mm-hmm. Not everybody can, but if you have a secondary email address, this is, again, it's somebody else in your office who is receiving the document and can calendar it and appropriately, discuss it with your client. Obviously, the implications of a proposal for settlement, request for admissions, right? There's so this all applies to documents which are not filed, but which are required to be served by court rule, by statute, by court order. And so just to make sure. Now, a lot of people have asked me, well, does this mean that my proposal for settlement will be invalid if I don't comply? If the recipient receives it? The appellate courts are going to figure this issue out. I've got arguments to make. Everybody's got theories on that, but just my general message is, don't put yourself in position to have to do that. If we can, exactly. Let's get it right now. Yeah. And not have to hire someone like me or someone else to try and make a creative argument. Better to get it right in the first place. That's my message for everybody from this decision. And so I think that's, I know we covered 3 cases today. I think that's it, Jeff, right? Unless you have any closing thoughts.
No, I think that's the agenda today, but I'm sure on the next one, we'll have more riveting cases like we always do. And we'll have Jen back. And, it's always a pleasure doing this with you, Andrew.
Thanks for joining. And for everybody out there, thank you for listening. Of course, if anybody's interested in coming on as a guest, whether it's for my podcast at Florida Appellate Review or here at PBCJ, the Palm Beach County Justice Association, we'd love to have you independently or together. If you want to come on and discuss cases, that too, we'd love to have you there. Just reach out to Jeff, Jen, or myself, and look forward to talking with you all soon. Take care, everybody.